being mocked and abused by prison guards, being mistreated, assaulted, or forced to stand naked in a jail cell for 10 hours. These despicable actions are all things we probably associate with other countries, certainly not our own. But it might surprise you to know that all of these things are not only happening in the United States, oftentimes they happen without repercussion or punishment of any kind. Although prisoners do lose some rights when they go to prison, they certainly retain some federally secured rights, along with human dignity. Dignity which the current legal system refuses to protect. And it's because of this that Caleb and I believe, or we stand resolved, the United States federal government should significantly reform its policies regarding convicted prisoners under federal jurisdiction. Now, before we get any further, we'd like to present a standard, or a weighing mechanism through which you can judge this round. And that standard is justice. We simply want to reach a more just system through passing our plan. Now let's examine the terms that are central to today's case, and the idea you can write down as context. The terms. The first term here is that of the Prison Litigation Reform Act. The Prison Litigation Reform Act, or PLRA, was passed by Congress in 1996, the goal being to weed out frivolous prisoner lawsuits. Although well-intentioned, this law created numerous hoops and needless red tape that have blocked prisoners from being able to access the courts. The second term you can write down is that of a frivolous lawsuit. A frivolous lawsuit is a lawsuit that is not based in fact or in law. The purpose is to make money or to waste time. For example, let's say certain prisoners don't like the food that they're served and decide to sue the prison. But in direct contrast to this, we have meritorious lawsuits. A meritorious lawsuit is a lawsuit about a serious issue, like a constitutional rights violation or abuse. Now, before we get into our problem, I'd like to start with one widely accepted legal principle. And you can write this down as right to access the court. Attorney Samuel Riley explains in the Emory Law Journal in 2021 that in Bounds v. Smith, the court recognized that it is established beyond doubt that prisoners have a constitutional right to access the courts. Attorney Melissa Bonarofe further elaborates in October of 2021 when she says, one of the most important rights recognized by the courts was a prisoner's fundamental right of access to the courts in the first place. Federal courts acknowledge that an inmate's right of unfettered access is as fundamental a right as any other. But unfortunately, this right is repeatedly denied by the problem we are trying to solve today. And you can write this down as red tape. Red tape. The red tape problem comes from a provision in the PLRA called the exhaustion provision. It requires that prisoners go through every single step of an internal administrative appeals process before being able to proceed to court. Under the PLRA, courts are forced to dismiss a case before it is even heard, if it hasn't checked every single box of that prison's internal grievance process. This provision offers no standards or time limits, and it allows each prison to create their own bureaucratic process. The red tape problem results in two distinct harms. Harm one, conflict of interest. Conflict of interest. According to the University of Baltimore Law Review, they note in 2015 that under the current model, a prisoner must submit his or her initial grievance to the same officials who create the procedural scheme, and who are often named defendants in the underlying action. This creates an inherent conflict of interest in the current administrative remedy scheme. To illustrate the absurdity of this system, consider attorney Stephen Bright's account of an inmate who had 5 days to file a grievance after being beaten by a guard with a sock full of combination locks. Because he was in and out of consciousness during this time period, he was unable to file, and his case was dismissed. This is absurd, but unfortunately it's not uncommon. Rules about tight deadlines, complicated paperwork requirements, and even ink color are all too prevalent. And the result we see in harm 2. Suits blocked. According to the attorney and judicial law clerk Ryan Lefkowitz, he said in 2018, the exhaustion requirement applies to all types of prisoner lawsuits. It has been constantly and aggressively applied by the courts, blocking prisoners' lawsuits from ever going to trial. Attorney Melissa Bonarofe further elaborates in October of 2021 when she says, thousands of prisoner civil rights cases have been dismissed for failure to properly exhaust administrative remedies without regard for the merits of those claims. So what is the impact of all of this? Well, you can write down 2 primary impact points here. Impact 1, thousands of cases denied. And impact point 2, access denied. In 2015, the University of Baltimore Law Review notes that the single biggest obstacle in the way of vindicating constitutional rights is the Prison Litigation Reform Act, specifically the exhaustion requirement. Failure to adhere to even the slightest procedural requirement is sufficient to warrant a dismissal, regardless of the merits of the underlying claim. Prisoners have a fundamental right to access the court, but because of the red tape and the exhaustion provision, described as the biggest obstacle to constitutional rights, it has facilitated an outright denial of prisoners' constitutional rights in abusive situations. And because of this, Caleb and I would offer the following policy. Mandate. Immediately, Congress will pass and the President will sign Section 3 of the Prison Abuse Remedies Act of 2009. One amendment will be made to this bill, and it will only apply to convicted prisoners under federal jurisdiction. Section 3 of the Prison Abuse Remedies Act, otherwise known as PARA, amends the exhaustion provision by adding a time limit. A prisoner will be given up to 90 days to file a lawsuit, or to resolve, after filing a lawsuit, to resolve the claim within the prison process. And the case will go to court 90 days after the lawsuit is filed and no resolution has been reached within the administrative remedy system. Our plan has three primary advantages. Advantage 1, rights restored. The Philadelphia Bar Association says that this amendment would, quote, ensure that prisoners are afforded meaningful access to the judicial system to vindicate their constitutional and other legal rights, end quote. Advantage 2, accountability reestablished. Law professor and practicing attorney Stephen Bright testified before Congress, saying that under our policy, quote, prison officials would have an opportunity to resolve complaints, but would not be able to dodge accountability with complex and technical requirements, end quote. And advantage 3 is frivolous litigation restraint. Our plan addresses the red tape problem by changing one of the provisions in the existing legislation, but it keeps all of the effective provisions in place. This includes the ability to dismiss frivolous cases. And you might hear from the negative team in today's debate round a couple of outrageous examples of cases that prisoners have brought. But I want you to keep this in your mind, that our plan addresses frivolous litigation. As described by the Columbia University School of Law, they say the PLRA requires federal courts to examine all suits by prisoners. The PLRA requires that a court dismiss a claim that is frivolous or malicious, and the court must dismiss these claims as soon as it sees them. There is a problem with current policy. Thousands of cases are dismissed because of a broken, bureaucratic system. By passing PARA, we restore constitutional rights to federal inmates. We reestablish accountability, but ultimately, we uphold justice.
All right, is everyone all set? Yes. 3 minutes on the timer, Nathaniel. Are you all set?
Yes.
All right, let's go ahead and get started. Great speech, Nathaniel, and congratulations on making it to finals.
Thank you, you as well.
Thank you so much. I just got a few questions for you regarding your policy proposal. But first of all, you would agree that without food in your system right now, you probably wouldn't be debating as well, correct?
That's probably true. I didn't have a very big dinner, so.
You would agree that I did bring dinner to this room at the start of this debate round for you, correct?
Yes, Josiah, I did give you my money.
So if you win this debate round, I can accept some credit for that, correct?
I suppose.
Can I have a copy of your first affirmative constructive?
Absolutely.
All right, can I pass this back to David?
Go ahead.
Thank you so much. I'd like to start off by your argument about the exhaustion provision and the access to the court system being denied. Now, what was the most recent example of a court denying access to a lawsuit because of the exhaustion provision?
Sure. So specifically, I read from Attorney Melissa Bonarofe talking about how thousands of cases are dismissed, and that evidence came from 2021.
Okay, but do you have a specific example?
Yeah, there are specific cases that we have that have been thrown out because of the exhaustion.
We'd love to see those. Thank you. You also brought up a piece of evidence from the Baltimore Law Review, I believe. It was in reference to the thousands of cases being denied.
I believe that evidence was under the point about how it is blocking constitutionally meritorious cases. But
Okay, perfect. What was the date on that piece of evidence?
that evidence was from 2015.
Okay, perfect. You would agree, or after your policy proposal, I'd just like to clear this up. You would agree that a prisoner wouldn't have to go through any means in the current system. They wouldn't have to work through any of the channels of the prison system and the regulations there. They could file a lawsuit.
So I actually wouldn't agree with that. Our policy doesn't get rid of the exhaustion idea. It simply puts a time limit on it. It puts an accountability mechanism in place to get rid of or mitigate this conflict of interest that exists.
And if they don't exhaust the provisions within that timeline, they can go straight to court, correct?
After the 90 days of pursuing exhaustion, they can go to court.
Okay, and is there any standard as to how much they have to pursue exhaustion, or can they just not do anything?
So in our policy, we talk about achieving a remedy to a situation, and so it's the job of the prison to work in that time constraint, to work with the prisoners to try and achieve a remedy to those situations.
Okay, sure. Now you would agree, you argued in your speech that the current policies are unconstitutional. You would agree that the Supreme Court determines whether or not policies are constitutional or unconstitutional.
That is the
correct?
role of the Supreme Court.
Okay, perfect. Now, you talked a lot about the exhaustion provision in your speech. Now, is an exhaustion provision such as the one in the PLRA unique to the PLRA?
I'm a little bit confused by your question. Exhaustion requirements can exist other places in law, but with the idea of no time limits or regulations or anything of that kind, it is unique in terms of the PLRA.
Okay, so there's no other exhaustion provisions in federal code that don't have a time limit?
Not that I'm aware of.
Okay, thank you so much. I'm out. We will start negative time at 5 minutes.
Okay, all judges ready? As Ronald Reagan once aptly put it, trust but verify. Now, the affirmative team has brought forth a very convincing case today, and on its face, I can admit it does sound like a good policy to pass. It seems like we have all this bureaucracy in our prisons that is stopping people from bringing legitimate cases to court. But when we look at it deeper, we can see that there's really no moral harm in the current system. And that even if it is, and that even if there is, that the affirmative team's plan will ultimately do nothing to solve it. Now, first we need to go over the harm that the affirmative team presented. Now, the affirmative team has presented the goal of justice, and I believe that we can really only measure the standard of justice by this. If the affirmative team cannot prove that there is a significant harm in the current system and that they have solved this harm in a just manner, then they have failed their goal of justice. Now, if they cannot prove the harm, that is the very, very first burden of proof here. And I'd really like to go over that. Now, so far at the start of their case, what they really brought before you were facts. Now, these are occurrences in the current system, and then they added a moral weight to those. However, I don't believe that that moral weight that they added to them was ultimately reasonable. Now, first off, they brought the issue of red tape, basically the bureaucracy that is currently in the prison system. Now, first off, I don't believe this is a reasonable standard. Now, the affirmative team's plan does nothing to solve this added bureaucracy to the prison system. The only thing that the affirmative team's plan is actually doing is adding a time limit. So instead, we'll simply have prisoners who are trying to fulfill all of this bureaucracy and simply have a time limit on it. The affirmative team has not brought up any examples of any prisoner who has actually brought up a legitimate lawsuit and completed this exhaustion clause within this amount of time. Now, specifically speaking, going back to the harm idea, the idea of the harm in the current system, if they cannot assign a moral reason as to why this red tape or why this bureaucracy is in fact wrong, then their ballot is simply not warranted because they cannot show that they're solving the non-existent harm in the current system. Now, how exactly would they show that there is a moral harm? Well, one main way is through quantification. Now, if they can successfully show a significant amount of prisoners, specifically convicted federal prisoners, that have actually tried to bring legitimate court cases but have failed the exhaustion clause in more than 90 days, then they actually have a significant moral harm. However, the affirmative team did not present this. There is no reason to believe that there is actually a significant number of prisoners who have completed this exhaustion clause within under 90 days. There's no reason to believe that this is a reasonable standard that the affirmative team is setting, and also no reason to believe that the current system is morally wrong. Now, I don't really disagree with any of the affirmative team's examples. I agree that bad things happen in prison. The reason that our justice system is called that way is because it's designed to give each man his due. And yes, absolutely, sometimes it fails. But simply adding a time limit on something and not changing the way that it fundamentally operates will not ultimately change that. We need to fundamentally change the way that something operates if it actually is wrong. And the affirmative team does not do that. First off, they do not show how the current system is morally wrong, and second, they don't really show how they can physically solve that. Now, second, they brought up the harm of blocking lawsuits in the current system. Now, what exactly would be a blocked lawsuit? Now, that it might be somebody who has failed the exhaustion clause, who tries to apply for this before they've actually exhausted the other proper means in the current system. Now, this would definitely be a legitimate reason to do that. Now, if somebody has not exhausted the proper rules in the current system, then there's no reason to give them exactly what they want. I think we can all agree that prisoners here want to have their case heard. Now, definitely prisoners have legitimate complaints, and prisoners sometimes have illegitimate complaints. The main issue here is whether or not they're getting to court for the right reason. And if the prisoner is trying to get to court for the right reason, but they aren't going by the proper channels, then there's no reason to grant them their wish. Prisoners still have to abide by rules in the prison, even if they don't always make sense. The affirmative team is not changing that whatsoever. They are not removing this exhaustion clause. All they are doing is adding a time limit. And they say that this will somehow get rid of blocked lawsuits. And I don't believe that it truly will. Now, next, I'd like to talk about how their plan will actually affect the current system. Will the affirmative team's plan actually have the positive output of justice, of giving each man his due? And I don't believe that it truly will. See, to truly give somebody justice, you first have to define what exactly justice would look like in the current system. And I don't believe that the affirmative team has done that. I don't believe that justice includes this exhaustion clause within a 90-day time limit. And if so, then I'd really like the affirmative team to bring up some advocacy, maybe some court precedent that really states that an exhaustion principle is a just idea with a time limit on it. Now, if they wanted to put a time limit on the current system, a time limit for a prisoner to submit an appeal to a court, or even a court case at all, then they'd really need to show why an exhaustion clause is ultimately necessary. And I don't believe that the affirmative team has done that. So overall, because the affirmative team cannot possibly show that there is a moral harm in the current system, and thus they cannot show a valid reason for changing the current system, and second, because they have not shown that they can actually solve the supposed harm in the current system, I believe that ultimately a negative ballot is warranted, because the affirmative team finally, at the end of this day, fails their goal of justice, of giving each man his due. Now, the affirmative team may look good on the surface, but when we actually try to verify the facts that they have brought before you, we can see that their logic itself does not add up. Their evidence may be sound, but the way that they're trying to use that evidence will ultimately not give prisoners what they are due. Thank you. Yeah.
Everybody's all set? David, I trust you're doing well tonight, and congratulations on making it to finals.
Thank you.
You as well. Questions. Starting off, is there a reason you chose to wear a black suit instead of a blue suit today?
I simply do not have a blue suit. I didn't think they were good enough for me.
Now, jumping right into some of these questions here, you can agree that prisoners do have a constitutional right to access the courts, correct?
Yes.
Okay, and if that right was being denied, that would be a significant problem, correct?
If it was denied for an illegitimate reason, then that would be a significant problem.
Okay, so they have a right, and if that's blocked, it does raise a significant issue.
Specifically if it's blocked for an illegitimate reason.
Okay, so you talked a lot about significance. Now we have to quantify the problem. Now, how do you prove significance? Is it just through numbers?
No, absolutely not. However, I also showed how there's no real moral harm.
You would agree that numbers can be, or that significance rather, can be proven through both quantitative and qualitative data, correct?
Yes, absolutely.
Okay, and so if we were to show a qualitative harm along with a quantitative harm, that would prove the significance of this policy, correct?
Generally speaking, yes.
Okay. Now your main argument was that there was no moral basis for this policy, correct?
Specifically, no moral basis for you considering the facts in the current system to be harms.
Okay, but we can agree that there is a constitutional right, and that right is being denied regardless of
I did not say that the
merits,
current system was actually denying these people their rights. The current system might be limiting these people's rights in some manner, but I never agreed that it was limiting it in an unjust way.
You would agree with me that the current system dismisses thousands of cases brought by prisoners, correct?
They might dismiss them. I fail to see how that's a moral
those
harm.
thousands of cases are dismissed without looking at the merit, correct?
The prisoner still has to go by the proper channels, so yes, they might dismiss them without looking at
Let's
the
talk
merit.
about that for a second. Let's talk about these proper channels. Let's say a prisoner is unconscious and is unable to fill out a form, and then is dismissed because of that. Is that just?
The prisoner is unconscious and fails to fill out a form. I fail to see exactly how that applies. I
Like
fail
the
to see how
example
that's
brought up in the
justice.
1AC, the individual who was beaten by a guard and was unconscious for the filing period. Is that a just system?
I'm a little bit confused on this.
Okay.
I'd really have to see a little bit of
We'll
clarification.
move on to
Sorry
the
about
next
that.
idea here. If an individual's case is thrown out because they file in the wrong color ink, is that a just system?
I generally say that that seems pretty arbitrary, and no, that doesn't seem super just
Yeah,
to
it's
me.
an arbitrary policy. Great. If a prisoner's claim is thrown out because they filed perhaps the wrong form because they're illiterate or can't understand it, is that a just system?
That wouldn't be a just system. The only problem is that your plan doesn't solve for any of these arbitrary rules being implemented. Your plan only adds a time limit.
Let's talk about that as well. You would agree with me that right now judges are required to dismiss because of failure to properly exhaust, correct?
Yes.
Okay, and you would agree with me that under our policy, the judges would have to look at these cases after the 90-day period had elapsed, correct?
I believe so, yes.
Okay, so by that logic, these cases would then be heard and evaluated on their merits, correct?
I don't know about heard. You said examined there.
They'd be examined in the court or heard in the court and evaluated on their merits, correct?
I'd really have to see a link between examined and heard in court. I believe there's a distinction there.
Okay, all right. Thank you, David.
According to Isha Anand, a Juris Doctor from UC Berkeley, he says in 2021, quote, instead of preserving judicial resources, the PLRA has helped to preserve cruel and inhumane conditions inside America's prisons. With the courthouse doors effectively closed, incarcerated people have few means to challenge or expose the conditions in which they are forced to live. Without access to courts, not only are individual harms never redressed, but proper systematic reform remains out of reach. Dangerous living conditions, the psychological horrors of solitary confinement, beatings, rape, or disastrous health care, all are concealed from view and persist unchecked, end quote. These are all the things that the lack of accountability has facilitated in the current system. And as of 2021, we see it's still a problem. In today's speech, I'm going to be going over the main ideas of argumentation that the negative speaker brought up and showing you how not only is there a significant problem in the current system, but that our 90-day time limit and cap would provide accountability and solve that problem. The first idea that he brought up is asking if there's a problem. And he said we kind of brought up evidence that was factual and assigned some sort of moral imperative to it. And so I'd like to have a few responses. The first you can tag as no response to our evidence. No response to our evidence. Simply saying that it's a fact and carries no moral weight isn't a response. I would remind you of a few pieces of evidence that we read. First, that thousands of cases are being thrown out because of the exhaustion provision, not being weighed upon their merits. Again, these cases are being thrown out because they have not checked every box of the hyper-technical requirements that the prison officials themselves create. The judges' hands are tied and are forced to throw those cases out. This is not a just system. They further did not respond to the evidence that we talked about that the exhaustion provision is supposed to be the biggest blockade of constitutional rights when it comes to the prison. They failed to respond to this, and further failed to respond to our evidence talking about how there's a complete conflict of interest and there's a lack of accountability in the current system. Simply saying that it's just a fact and carries no moral weight actually holds no weight when you don't respond to the evidence, and we see that those facts remain in the current system. The next idea in response to this you can tag as no accountability in the status quo. No accountability in the status quo. Professor of law Margot Schlanger reports in 2008 talking about the whole issue of the exhaustion provision. She said, quote, when federal courthouses are barred to constitutionally meritorious cases, the resulting harm is not merely to the affected prisoners, but to our entire system of accountability that ensures that government officials comply with constitutional mandates. The erection of hurdles to accountability should not be seen as reducing the burden for correctional administrators. It should be recognized as weakening the rule of law. The PLRA must be amended, end quote. It doesn't just harm every little system that's happening, it harms the whole system of accountability inside of prisons. The prisons get to create the requirements and rules that the prisoners must exhaust before the judges can hear the merits of the case. So there is a problem, a significant problem in the current system. The next idea that they brought up was a question, essentially how many prisoners are filing meritorious cases that are getting thrown out? And you can tag my response as merit, not evaluated. This is actually the biggest part of the harm that Nathaniel and I are presenting in the current system. Every case, every prisoner has the right of access to court and to have their case decided whether it's a meritorious case or whether it's a frivolous case. But in the current system, the exhaustion provision prevents the merit of the case to ever be looked at. We can't come up here and say, here's how many are meritorious, because the cases are thrown out before it ever reaches that point. According to David Fothy, a JD from UC Berkeley, he writes in 2009, quote, "The exhaustion requirement has nothing to do with the merit of the prisoner's underlying claim. It requires dismissal of the case regardless of its merit if the prisoner has failed to comply with the procedural requirements, however petty, of the prison grievance regime," end quote. We can understand that in the current system, the exhaustion requirement is not a standard that looks at merit. It doesn't say whether a case is frivolous or it doesn't say whether it's meritorious. Instead, if a prisoner has not gone through every single process, every single requirement, and has not checked every box, that the judge is forced to throw away the case regardless of its merit. Now, Nathaniel and I recognize that having some exhaustion is important in the current system and that prison officials and prisons should be the first ones to address issues going on. But we further understand that there must be accountability if the prison is unable to do so. And that's why we have presented our plan today. The next response you can tag to this whole idea of how many are meritorious, you can tag as most are serious issues. Now, you might be wondering, I just came before you and said that we can't exactly evaluate. But what we can understand is that overall, most of the issues being brought are serious issues, even though the courts are not able to look at them. According to Brian Stoll in April 2021, he says, quote, "The reality is that most cases filed by incarcerated people, both before and after the PLRA, raise serious issues," end quote. So we understand that the problem is twofold. First of all, the judges can't even look at merit. They have to throw the cases away if they have not exhausted every administrative remedy. But number two, we see that the majority of these cases being thrown away are indeed meritorious and should have the right to access the court, as the Constitution and the Supreme Court has affirmed. The next idea that they brought up is essentially that prisoners should have to, a couple ideas that he brought up. Prisoners should have to exhaust provisions or exhaust administrative remedies, that the prison officials should have the first opportunity to remedy this, and essentially he said we're not necessarily helping the bureaucracy, we're just providing a time limit. And I have a few responses to this. The first you can tag is 90 days correct. 90 days correct. And I'd like to explain a little bit on how the 90-day time limit actually helps with the bureaucracy and provides accountability. I'd like to read from attorney Stephen B. Bright when he testified before Congress, and he talked about our specific mandate under the Prison Abuse Remedies Act, the section that we're passing. He writes, quote, "The Prison Abuse Remedies Act would correct the problem by allowing federal courts to stay proceedings for up to 90 days to permit prisoners to exhaust administrative remedies. Prison officials would have an opportunity to resolve such complaints, but would not be able to dodge accountability by asserting inmates' failure to comply with complex and technical requirements," end quote. What he understands is that prison officials under a policy would have the opportunity to help in the first place, but if they cannot provide that help, then accountability is established with the right of access to the court being given. And this is actually a judge recommended as well, as Stephen B. Bright continues in its testimony. He gives an example saying, quote, "A prisoner who had been beaten by other inmates maintained that he had failed to file a grievance within the 15 days required because he had been hospitalized. The magistrate judge recommended staying that case for 90 days to allow him to exhaust, as the amendment in the Prison Abuse Remedies Act would permit. These are not isolated examples, and they do not begin to tell how many cases are not brought, because it is clear that they will be dismissed for failure to comply with grievance procedures," end quote. This evidence has twofold things that I'd like to look at. The first, that it's not isolated examples. This is happening, the problem is happening all the time. And secondly, even judges recommend that 90 days be the correct amount of time. Furthermore, I'd like to give advocacy from the American Bar Association that says this is the correct policy. According to the American Bar Association in 2010, quote, "A prisoner who files a lawsuit with respect to prison conditions but has not exhausted administrative remedies at the time the lawsuit is filed should be permitted to pursue the claim through the grievance process, with the lawsuit stayed up to 90 days pending the administrative processing of the claim. After which, a prisoner who filed a grievance during the period of the stay should be allowed to proceed with the lawsuit without any procedural bar," end quote. We have judges, we have attorneys, we have lawyers, and we have experts who recommend that there be exhaustion, but after that there be accountability and access to the courts restored.
Zero the clock. The affirmative speakers ready?
I'm all set.
All right, the panel of judges is all set. Go ahead and get started. First off, congratulations on making it to final. I just had a couple of questions for you. Thank you. First off, why a blue suit?
And I just think that Daniel and I look very good.
So is it just a matching factor, or is there a moral decision behind it?
I think this one carries more moral weight than any argument we'll make in this debate.
All right. Now getting a couple more serious questions. Can I just have the evidence that you provided on the accountability provided by your plan?
Yeah, so it was this piece that I have tagged with the yellow mark.
Okay, thank you. Would you mind if I pass it back to my partner?
Yeah, actually there was one more on accountability that I'll give you as well.
Yeah, thanks. That would be great.
So I'll take the other tags off. It's this other one that talks about how accountability is established, of course.
Now you can generally agree that frivolous lawsuits have negative consequences to the court system, correct?
I don't think frivolous lawsuits are ideal.
Okay, so they basically have a couple of negative connotations.
Sure.
Okay, and you're essentially allowing frivolous lawsuits to happen in the current system, correct?
We're allowing frivolous lawsuits to happen in the current system. Our policy hasn't been passed, so we're not allowing anything.
But, sorry, I'll show you this. After your plan was passed, you'd essentially be allowing frivolous lawsuits.
Absolutely not.
Okay, and how exactly do you protect against frivolous lawsuits?
So I would refer you back to our Manage 3, where we talked about how frivolous standards are left in place. We recognize that the exhaustion provision doesn't actually stop frivolous litigation, but there are standards that does stop frivolous litigation, and those we leave in place.
Interesting. So, are you acknowledging that the frivolous rules that prisons put in place to stop frivolous lawsuits, are you saying that those work or don't work?
Yeah. So I think I could clarify a little bit. The exhaustion provision and the frivolous standards are two different things. The exhaustion provision says they must exhaust all administrative remedies, which we talked about, and the frivolous standard says that if a court has a frivolous case that comes before it, that it gets dismissed in the earlier screening. It's two separate standards.
Okay, so you'd agreed earlier in your speech that some exhaustion is ultimately necessary, correct?
I would agree that prison officials should have the first opportunity to resolve the complaints by the prisoners.
Gotcha, okay. Now, you brought up a meritorious majority, basically that the majority of court cases brought before court are essentially meritorious and not frivolous. Could I actually see the evidence that you read on that?
Of course. Here you go.
All right, thank you very much.
Thanks.
And just to clarify once again, you're not really changing any of the regulations that prisons have in place. You're simply adding this 90-day time limit and allowing the cases to be heard before court after that 90 days?
Again, they must pursue administrative remedies within the 90 days as exhaustion is still in place.
Absolutely.
But after that, if exhaustion has not been completely resolved by every process, it then can be evaluated on its merits by the court.
So essentially, frivolous lawsuits will still be heard by the court if they pursue the exhaustion principle.
No, exhaustion is different from frivolous lawsuits or frivolous standards. That's what I'm trying to explain. Do you want me to go into a little bit more so I can clarify, or do you want me to stop there?
No,
I
I
don't want
looks
to
like we're out of time. We can clarify more in future speeches.
Okay, I appreciate it, David.
Thank you. Starting a little bit of prep time, starting at 3:20.
All right, is my panel all ready? Yes. You got 8 minutes for the timer? You guys all set? We're all set. And I will go ahead and get started. I'd like to start off this second negative constructive of this debate round by clarifying that while I agree with almost everything that David said in his last speech, I do disagree with the idea that black suits are somehow better than blue suits. In this instance, I would have to side with the affirmative team, and that argument should flow affirmative. With that, I'd like to get into the main core of my argumentation in this speech and the negative team's argumentation in this debate round. Before I get too far, I'd just like to clarify one thing and make one request of the affirmative team. I request that they do not bring up any evidence regarding the PLRA as a whole, and they only bring up evidence regarding the exhaustion provision itself, because that is the only thing they will be reforming. In addition to that, I request that they do not bring up any evidence talking about the benefits of the PARA Act as a whole, and only bring up evidence regarding the benefits of Section 3 of the PARA Act, because once again, that is the only thing that they are reforming. Any other evidence not specific to Section 3 and not specific to the exhaustion provision should not have merit in this debate round and should not have weight for your decision. With that, I'd like to lay one burden of proof on the affirmative team, and that you can simply tag as a recent problem. Now, the resolution mandates that we make a significantly reform our policies, but the reform has to be regarding a recent problem. We can't make changes or make policies regarding problems that existed 5 or 10 years ago. The policies that we should make should be regarding harms or problems that we see in the current system, not the system that we had 5 years ago. Now, I asked in the first affirmative cross-examination of an example of the most recent example of the exhaustion provision, of a case being denied because of the exhaustion provision. He wasn't able to give me the most recent example. In fact, he wasn't able to give me any example. He simply said that they had a piece of evidence from 2021 talking about how thousands of cases had been denied. It didn't say in this piece of evidence that thousands of cases had been denied in 2021. It didn't say when these thousands of cases had been denied. And so I'd still like to ask the affirmative team to present either the most recent example of a case being denied because of the exhaustion provision, or how many cases were denied in 2020 or 2021 or even 2022. Without proving an actual serious problem, not only in the past, but in the current system, an affirmative ballot is simply not warranted, and a solution shouldn't even be considered. With that, I'd like to get into the first solvency point of the negative team, or of this debate round, and that you can simply tag as filing period unchanged. Filing period unchanged. Now, in their piece, the first affirmative constructive, they brought up what sounded like a horrific example, specifically talking about Stephen Bright. Now, he was beaten unconscious, and because of that, he didn't have the opportunity to file his claim within the filing period. The problem is this has absolutely no impact on this debate round because the affirmative team does absolutely nothing to change the filing period. I'd actually like to read the piece of evidence that they provided me. It says, quote, "In another case, an inmate was beaten with a sock full of combination locks. Filing a grievance was not the first thing on his mind during the 5 days he had to file one. He was in and out of consciousness during that time. Nevertheless, it was argued that he could not file suit because of his failure to comply with the deadline. It never said his failure to comply with the exhaustion provision. It simply said his failure to comply with the deadline. However, PARA, specifically Section 3 of PARA, mandates that that deadline still stay in place. It says such presentation, in Section 3 it says, such presentation as to satisfy the requirement of this paragraph if it provides prison officials of the facility in which the claim arose with reasonable notice of the prisoner's claim, and if it occurs within the generally applicable limitations period for filing suit. So those limitations on the time period as to when you can file a suit still exist after the affirmative team's policy proposal, so that system would not change. The harm that they brought up, the horrific example of a prisoner not being able to file a claim, would still exist if you vote affirmative. And so this cannot be used as a reason to vote affirmative. The second solvency point you can tag is insufficient remedies. Insufficient remedies. And ultimately, if we look at the system that the PLRA has established and the rest of the bill that they're not reforming, it also limited the ability to provide remedies for the prisoners. According to Christopher E. Smith and Christopher E. Nelson in January 21st of 2021, quote, simultaneously, the PLRA diminished judges' authority to order remedies in cases concerning prisoners' rights. So even if you amend the exhaustion provision, even if you take that limitation away, the judges are still severely limited in the remedies that they are able to provide to prisoners. And once again, that is something that is completely unchanged by the affirmative team. With that, I'd like to look at the disadvantage and the main disadvantage of the negative team in this debate round, which you can simply tag as frivolous litigation. Frivolous litigation. Now, it is our contention that the problem of frivolous litigation will severely and drastically increase after an affirmative ballot. In regards to this, I'd like to lay another burden of proof on the affirmative team, and that would be simply that the cases denied were not frivolous. They have to prove that the cases denied were not frivolous litigation. And to back this up, I'd like to read a piece of evidence from Celeste Valencia and Charles Dyke. And the piece of evidence said, quote, the PLRA managed to curtail the number of frivolous pro se lawsuits by requiring inmates to exhaust available administrative remedies before filing a lawsuit. So specifically, the exhaustion provision of the PLRA reduced the number of frivolous lawsuits. It goes on to say, quote, from 2000 to 2007, the number of federal claims based on deficient prison conditions dropped by 31%. So they have to prove that the claims made were not frivolous, because this piece of evidence actually clearly said that the exhaustion provision has drastically decreased the number of frivolous litigation claims. With that, next I'd like to respond to their Advantage 3, where they basically said that frivolous litigation was protected against with the PLRA. I'd like to read their piece of evidence. It says, quote, the PLRA requires federal courts to examine all suits by prisoners. The PLRA requires that a court must dismiss cases that are frivolous or malicious. The court must dismiss these cases as soon as the court sees them. However, the problem with this is that this already exists. Yes, the court is supposed to immediately dismiss any frivolous case. However, once a frivolous case goes to court, that damage has already been done. The problem with a frivolous case is not that they're not dismissed, not that they're judged on in the wrong way, but the fact that they get to the court in the first place, which once again the affirmative team does not protect against. So those frivolous lawsuits, that frivolous litigation, would still get to court, and the safeguards in the PLRA simply do not protect against frivolous litigation. Ultimately, many of the harms that we see and many of the advantages that they claim cannot be brought about by an affirmative ballot. They either represent something that is completely unaffected, or they represent a problem that simply does not exist in the current system. And for the reasons that I have presented, I strongly urge a negative ballot.
First of all, congratulations on making it to finals.
Thank you so much. You as well.
Thank you. I do just have a few questions.
Sure.
But first, can we agree that prisoners in general do have the right to access the courts?
Yes.
All right, wonderful. Now, you can agree that as of 2021, we read evidence that thousands of cases overall have been thrown away specifically because of the exhaustion provision.
Yes.
All right, and we can further agree that I opened my last speech with 2021 evidence saying that the courthouse doors, because of this, are effectively shut, correct?
Yes, but that didn't say that that was specifically in regards to 2021, or those thousands of cases that have been denied were from 2021.
Sure, but as of 2021, the courthouse doors are still effectively shut according to the evidence, correct?
Okay, first of all, that was talking about the PLRA as a whole, and it was not specific to the exhaustion provision. In addition to that, to give an additional response, I'd have to look at that specific piece of evidence.
All right, wonderful. We'll talk more about that. Now, you talked about how we're actually making the filing period longer. Now, we can agree that there's two different time limits we're talking about. One would be the time limit under the exhaustion that prisoners create, a certain amount of time that a prisoner has to file their claim, and that was the example, correct?
Right.
All right, and we can agree further that we're talking about on a time limit on exhaustion as a whole, not the time to file the claim in the first place.
Yeah, exactly.
Correct?
You're not changing the time period that you have to file a claim within, which was the main problem with that example.
Understood. And we can agree in the current system that the judges would be forced to throw out that case because it failed exhaustion in that prison, correct?
No, because it failed because of the fact that he failed to file it within the time period.
Which was part of the exhaustion provision.
No, it doesn't reference the exhaustion provision at all in that piece of evidence. It specifically references the time period to file a claim, which your plan doesn't change.
Sure, we'll talk a little bit more about that as well. Now, you talked about how judges, could I get the piece of evidence that you read about judges? I believe you read one piece of evidence referring to what judges can do. I don't quite remember what it was, but I wrote down that I want the piece of evidence.
Oh yes, this should be the one. It was the last half.
Okay, that makes sense.
If that's not it, then just let me know.
Now, you talked about how exhaustion provision was supposed to stop frivolous cases, correct?
Yes, that
All
was
right, and we can agree that that was its original intent to help stop frivolous cases, correct?
absolutely. And I also read evidence that it was working in that purpose, and it was
Interesting. Can we agree that we see that it's thrown out both frivolous cases and meritorious cases alike?
not necessarily. I wouldn't be able to do it.
Even though we read evidence that it's consistently and aggressively applied to all prisoner lawsuits, correct?
You have not proven that a single case that has been thrown out has been meritorious.
All right, even though I read evidence in my last speech saying that most of the claims brought up raise serious problems, correct?
Once again, you haven't proven that a single case that has been thrown out has been meritorious.
All right, but we can agree that the judges in the current system don't even look at merit, but must throw the case away if it has not exhausted every administrative remedy.
If you don't go through the proper channels, that is a result of it.
All right, thank you.
Thank you, Kolssak. Thank you.
I'd like to bring you back to my very first speech where I said you should trust what the affirmative team said, but still verify it with the current system, and really examine whether or not there is a moral harm to what the affirmative team is saying the current system is, and if there is a moral solution in the affirmative team's plan. And I'd really like to re-examine a lot of what the affirmative team has said in response to a lot of their arguments, as well as bringing forth a disadvantage to the affirmative team's case at the end of the speech, which is what we brought up in the second negative constructive. First off, we need to once again examine the harm in the current system. Now, the affirmative speaker, Caleb, brought up the idea of the conflict of interest in the current system. Now, we can generally agree that there might be a little bit of a conflict of interest with filing a report of abuse against the very prison system that abused you. The only problem is that doesn't fix the problem. Now, this prison system that has abused the prisoner is essentially a permissive environment. Now, this won't be solved by hiring or firing any new or old correctional officers. This can only be solved by a fixing of policy. Now, this can come about by means of a lawsuit, and this is ultimately what I believe the criminals are trying to do when they bring forth their case before a judge. And that's great and everything. The only problem is this conflict of interest applies after the court case as well. And the affirmative team cannot possibly solve this. Now, my partner hinted at this a little bit in his speech, but basically this conflict of interest is something that the affirmative team cannot fix. Even if they can fix whether or not the case is dismissed due to this conflict of interest, they cannot fix whether or not the case is actually remedied due to this conflict of interest. Now, the judge can say that the prison should remedy this policy, or say that the prison should change its policy regarding how it treats prisoners, and it can say whatever it wants. The only problem is the judge does not have this enforcement. The only enforcing power really falls on the hands of the prison. The prison which the affirmative team is saying is abusing the prisoners. And once again, this is a conflict of interest that the affirmative team cannot possibly solve. So we have a harm that the affirmative team brought up that they can't really solve, that will still exist in another form after their plan is passed. Now, second, we have the issue of frivolous lawsuits. Now, the affirmative team brought up that frivolous lawsuits are essentially why the PLRA's exhaustion principle is in place right now. However, what the affirmative team hasn't shown is exactly why it's wrong to dismiss frivolous lawsuits, and exactly how many meritorious lawsuits have been dismissed. Now, once again, my partner hinted at this more in his speech, so I'll simply leave that there. They essentially need to provide evidence showing exactly why it's wrong to either to dismiss frivolous lawsuits with the exhaustion principle, or why it's exactly correct to hear frivolous lawsuits. And that's going to lead me directly into my second point in this speech, specifically the system that you're left with after the affirmative team's plan is passed, or rather the solution that the affirmative team offers you. Now, if the affirmative team's plan is passed and Section 3 is ultimately, and the time limit is ultimately added, what will actually be changed? And the answer is really not that much. Now, first off, we will be allowing frivolous lawsuits. Now, Caleb already agreed that this has negative connotations and it has negative effects on the system. So this is already a minor disadvantage to the affirmative team's case. But allowing frivolous lawsuits is really something that the PLRA was implemented to stop. We're really not supposed to have frivolous lawsuits in the court system. This is essentially arbitrarily honoring a misuse or an abuse of the justice system. And this is something that I don't believe we should be honoring. The affirmative team is arbitrarily honoring this by not changing the exhaustion principle and not changing the arbitrary rules that prison set for the exhaustion principle. They're not really changing how many frivolous lawsuits have to be heard. Once again, my partner went over this more in his speech. No matter how much time is ultimately spent on these frivolous lawsuits in court, the damage is already done. And the negative connotations or the negative effects on the system have already happened. The affirmative team cannot possibly solve this because it's not in their mandate. They're not reforming this in any way, shape, or form. Now, second, we cannot possibly control the court remedying the problem. Now, the affirmative team has presented this conflict of interest and this abuse of prisoners, and this not really being heard due to this conflict of interest as I believe one of the main harms in the current system. However, what I believe this shows is more of a sign of a permissive environment in the Federal Bureau of Prisons, and specifically a permissive environment regarding abuse of prisoners and then the denying of those prisoners to have their case heard in court. Now, this permissive environment can once again never be solved by the affirmative team. They cannot possibly hope to solve this because they have no control of what happens after the judge lets the case go. Even if the judge votes in favor of the prosecutor, even if the judge votes in favor of the criminal who had his rights abused in prison. There's nothing stopping the prison from continuing to abuse the prisoner's rights, and this will simply lead to an endless loop of maybe meritorious lawsuits, but simply an endless loop of an abuse of prisoners' rights. This is something that the affirmative team cannot possibly hope to solve. So at the end of the day, I believe that we see that the blue suits cannot possibly uphold justice, simply because they presented harms that they cannot possibly hope to solve. Thank you.
Beginning prep time at 4 minutes.
If my panel is set, go ahead and get started. Nelson Mandela once said, "You never truly know a society until you spend time in its prisons." A society should not be judged by how it treats its highest, but by how it treats its lowest. And unfortunately, how we treat our lowest, those who are in our prisons, is in an abysmal fashion. Currently, they can be beaten, mocked, abused, and assaulted without any legal recourse that can be taken. And that is the problem in the current system. In this speech, I want to go over the arguments or the ideas posed by the negative team in this round. And what I'll show you is that the majority of what they've brought up actually hasn't been arguments. It's been questions. So I'll answer the questions and respond to the one argument they had of frivolous litigation. First, looking at the question of whether this is a recent problem. In our first speech, we read evidence from 2021, saying that thousands of cases were dismissed. But to further show the harm that exists in the current system, I'd like to read you a couple more pieces of evidence from 2021. According to the John Boston Legal Aid Society, he said in 2021, more prisoners lose their cases for failure to exhaust administrative remedies than from any other part of the PLRA. From recent evidence, the exhaustion provision is a problem that continuously results in dismissals. The second response here is that the law hasn't changed. In the midst of all of these years since the PLRA has been enacted, since 1996, the law has not changed, and as such, the harm has not changed. The problem still exists. This second brings me to the idea that courts are limited in what they can give to these prisoners, and I would actually agree with this. To some sense, courts are limited. The PLRA has limited monetary compensation for those who are in prisons, but the exhaustion requirement has stopped them from getting any kind of relief in a situation. What our legal system has is something called injunctive relief, basically where you can remedy an abusive situation. But right now, because prisoners are not able to access the court, their abusive situations cannot be remedied. Our policy gives them access and allows these remedies to take place. The second thing we look at is the idea of solving for abuse. And we can't solve for all abuse, and we're not claiming to solve for all abuse. But here's what our policy does. It allows these prisoners to be heard, to have their day in court, and to effectively remedy the abusive situations that they are in. It may not solve every single case of abuse, but it allows these prisoners to be heard, and it allows these prisoners to be protected. Third, we look at the concept of frivolous litigation. And this is basically the entire argument that they've made in today's debate round, that frivolous litigation is going to increase and that it's going to be a problem in today's debate round. Now, the first thing I have in response to this, and they asked how many of these cases were meritorious, is the idea that it's an impossible standard. An impossible standard. It is quite literally impossible for Caleb and I to show you how many are meritorious because it is the entire harm in the current system. The fact of the matter is that the court system does not look at the merits of these claims, and that is the problem. But the second thing we see here is that it ultimately only harms those who file the most or who file the least amount of lawsuits. This is from the University of Baltimore Law Review, and they note in 2015. Frequent flyers, those who file most frivolous lawsuits, are seasoned professionals in navigating the prison grievance system requirements and are not deterred by the exhaustion requirement. They know precisely what it is and precisely what is required to properly exhaust administrative remedies because they have done so with regularity. The exhaustion provision only impacts the first-time filers who until suffering some constitutional deprivation have never encountered the prison grievance system. It is precisely this prisoner who needs the most judicial access. Yet the exhaustion provision prevents this from occurring. Essentially, here's what we can see. The exhaustion provision does not stop frivolous litigation. It stops meritorious claims, those who have real constitutional issues, from being able to access the court system. I'd like to look at a couple different things that they talked about here. Josiah brought up the idea of deadlines, that effectively we're not changing the deadlines, but here's what our policy does. Right now, there is no accountability, and that's the harm under conflict of interest, that there's no accountability for these prisons. By imposing a 90-day time limit, we provide accountability so that these prisoners can be heard and effectively have their cases remedied. And this brings me to the final point in this speech. You can write it down as a voting issue, something to take back with you as you make your decision, but this is the moral imperative. The moral imperative. Nelson Mandela had it right when he said that a society should be judged by how it treats its lowest. And right now, prisoners are being beaten, mocked, and abused. Their constitutional rights are being violated, and the exhaustion requirement is the biggest obstacle to vindicating those constitutional rights. The facts line up with the morals in this instance, that right now there is a moral necessity to give these prisoners access to the court to vindicate their rights. Thank you.
We are restarting prep time at 2:23.
Let's go ahead and get started. In today's final negative speech of the round, I'd like to go over 3 main voting issues, what I believe to be the most important issues in this debate round, and what you should make your decision off of. But ultimately, it comes down to one question. Will the affirmative team's policy effectively reform a substantial problem in the current system? Unfortunately, I don't believe the answer is yes. I'd like to start off with my first voting issue that you can simply tag as no recent problem. No recent problem. Now, they brought up 2 articles from 2021 talking about how the exhaustion provision significantly limits, or has significantly limited in the past, the number of and has denied a lot of cases. They once again ignored my burden of proof as to the most recent time a case was denied because of the exhaustion provision. So because I assume they would bring that up if they had it, so I'll assume they do not have the most recent example, but ultimately we haven't seen a single example from 2020, 2021, 2022. We have no recent problem that is being solved or to solve by the affirmative team. Ultimately, they haven't provided you with a substantial harm in the current system. And so regardless of the merit of the affirmative team's policy, if the merit of the affirmative team's policy is regarding a problem that existed in the past, it simply should not be weighed and taken into consideration. So simply off of that, I believe a negative ballot is warranted. With that, I'd like to get into my second voting issue, which you can simply tag as no solution. No solution. Now, my first argument is that the system itself will not change. The affirmative team should not be arguing the advantages of stopping abuse. They should not be arguing the harms of abuse in the current system. The only harm that they should be arguing is the lack of access to the court system, because they're not stopping abuse. Their plan only changes the reaction to the abuse. It in no way affects the abuse and how it occurs in the prison system. So the emotional appeal of abuse happening, while that is horrific and while that is sad, and while I completely disagree with the way some prison officials act, it has no merit in this debate round and it should not be taken into consideration. In addition to that, I'd like to talk about the filing period. Now, there's a significant difference between the 90-day time limit that they're instituting on the exhaustion provision, and the time period in which you have to file a claim. One is not changed, and that is the one that brought about many of the harms, such as the one of the person being unconscious and not being able to file his claim within the time limit. That was a harm that they brought up, and a harm that their policy will have simply no effect on. And I'd also like to once again talk about the argument that of insufficient remedies. And while I believe that having access to the court system, even if it's not able to provide substantial remedies, is in certain circumstances a good thing, they did agree that the court system is significantly limited in the remedies that it is able to provide. And my final voting issue you can simply tag as the disadvantage of frivolous litigation. Frivolous litigation. Now they basically said that I'd like to first of all bring up the burden of proof once again that the cases denied were not frivolous. I asked them to prove that the cases that were denied were meritorious or that they were not frivolous. They didn't provide that. In addition to that, they never responded to my piece of evidence saying that the the exhaustion provision of the PLRA significantly reduced the number of frivolous lawsuits specifically in correlation to the exhaustion provision. Frivolous litigation is damaging to our court system. It takes up time in the court, but it restricts the access of people to the court system because of that backlog. It's not just a problem that we can throw around and act as if it doesn't matter. Frivolous litigation is a problem, and ultimately it leads to that harm of decreased access to the court system. However, the specific exhaustion provision that they are taking away or substantially reforming is the most effective safeguard against frivolous litigation. And this specific argument hasn't been responded to. In addition to that, they never responded to my response to the advantage 3 in their argument that there were safeguards in the current system. They never responded to my argument that they simply weren't sufficient and they don't actually stop frivolous litigation. They haven't presented you with a harm in the current system. They presented you with a harm that existed sometime. We don't know when. We don't even know the last time a court case was denied because of the exhaustion provision. That in and of itself warrants a negative ballot. But in addition to that, they can't prove an actual solution to the harms that they themselves have read. And in addition to that, there is a significant disadvantage of frivolous litigation. Thank you all so much.
The current system is unconstitutional and unjust, and the affirmative team's plan remedies that problem. Now today I'd like to give you 3 voting issues to demonstrate the claim that I've just made. The first voting issue you can tag as rights to access the court. And I remind you that this idea has gone uncontested in today's debate round. As established by the Constitution and reaffirmed by the Supreme Court, prisoners have the right to access the courts. I'd like to reread evidence that we read in our first affirmative constructive, according to J.D. Melissa Benaroff in October of 2021. She writes, quote, "One of the most important rights recognized by the courts was a prisoner's fundamental right to access the court in the first place. Federal courts acknowledge that an inmate's right of unfettered access to the courts is as fundamental a right as any other," end quote. So we understand that it has been an uncontested claim that prisoners have the right to access the courts. This leads me directly into my second voting issue, and that you can tag as access denied. Access denied. While understanding that prisoners do have the right to have their cases heard in court, we can further understand that the exhaustion requirement denies the privilege that they have to get to the court. The first subpoint you can write down as judges' hands bound. It has gone completely unresponded to as well after I brought up this idea that the exhaustion provision does not look at the merits or the frivolity of a claim. Rather, it's thrown away if it has not checked every box of the exhaustion provision. Yes, its original intention was to stop frivolous litigation, but it has failed to do that. I'd like to read you this evidence again that I read earlier. According to JD from UC Berkeley in 2009, he wrote, quote, "But the exhaustion requirement has nothing to do with the merit of the prisoner's underlying claim. It requires dismissal of the case regardless of its merit if the prisoner has failed to comply with the procedural requirements, however petty, of the prison grievance regime," end quote. So we can understand that in the current system, the exhaustion requirement has not been used to stop frivolous suits and allow meritorious lawsuits. No, it doesn't look at merit at all, and that's what the problem is in the current system. The first idea that he brought up was that of a recent problem. And my first response to this is that throughout this whole debate round, they have not given any evidence that the problem has changed or given any evidence that there's somehow a solution in the current system. They're simply saying that we must prove a recent problem. So they've given no evidence in the contrary. But I would make the contention that we have proven a recent problem, and that is for a few reasons. We've read evidence from 2021 saying that the courthouse doors because of the PLRA are effectively shut. We've read evidence from 2021 that overall, while the exhaustion provision has been implemented, thousands of cases have been dismissed regardless of its merit. We've read evidence as of 2021 that exhaustion is the main thing that is used to dismiss cases, and I'd like to reread this evidence. From John Boston from the Legal Aid Society in 2021, quote, "More prisoners lose their cases because of failure to exhaust administrative remedies than from any other part of the PLRA," end quote. And lastly, we read evidence in our 1AC talking about how the PLRA's exhaustion provision is consistently and aggressively applied to all types of litigation overall. So we can understand that the problem is recent and the problem remains. They've been again pressing us for meritorious numbers, but that is exactly the problem in the current system. The judges can't look at merit, but must look at if they've checked every box of the hyper-technical regulations that they require. Now, they've made one main argument in today's debate round, that of a disadvantage, and I'd like to have a few responses to this idea of frivolous litigation. The first is we leave frivolous standards in place. Back in our Advantage 3, we talked about how exhaustion doesn't look at frivolity, as we've talked about, but there are certain standards that the PLRA established that do. We leave those standards in place because we recognize that frivolous litigation should be thrown out. But my second response to this is that the exhaustion provision only hurts meritorious filings. My partner read evidence, and very important evidence that went unresponded to, that talked about how those filing frivolous litigation have learned the administrative grievance processes. They're not bothered by it. who are bothered by it are the people that have had a first-time constitutional violation, haven't experienced this internal prison grievance processes, and then are blocked by having their cases removed from court. We see that frivolous filers are not deterred by the exhaustion requirement. The people that it hurts are the ones with meritorious claims that should be being heard in court. Secondly, he talked about how the system won't change and we won't essentially solve the abuse. And I wish I could come up here with a plan that ends abuse completely, but we cannot do so. Well, what I can say confidently before you today is that we provide accountability and access to court when abuse happens. When abuse happens, it's already against the law and we can't mandate abuse ends, but we can provide accountability. Which leads me to my third voting issue, justice upheld. Justice upheld. The last argument that they made was that essentially we're just changing the time period and that the filing period remains the same. But I remind you, in the current system, if they fail the exhaustion provision, that case must be thrown away, but under our plan, if they were to do so, it can be heard in court. So even if they have some ridiculous requirement, that can be heard. We uphold constitutional rights and justice under our plan. Thank you.
Okay,